People v. Williams, counsel.
Afternoon. My name is Ayushi Misra from Cleary Gottlieb, and together with the Office of the Appellate Defender, we represent Mr. Raymond Williams. I'd like to reserve 3 minutes for rebuttal, please.
Yes.
Thank you. Your Honors, this is a legally insufficient case. The most objective piece of evidence here is a surveillance video that shows only innocent conduct by Mr. Williams. And the
Counsel, our
surveillance-
standard for legal sufficiency isn't a finding that a finding of guilt must be the only reasonable interpretation. Is that correct?
That's right, Your Honor. And
So the dissent got that wrong when they were in their dissent, the standard, outlining the standard?
So I think the dissent had focused on People v. Way, and the subsequent decision by this court, People v. Reed, did not overrule People v. Way, but we agree with respondent that the correct standard is whether the evidence provides a valid line of reasoning and permissible inferences from which the jury could infer that the prosecution established all elements of the crime.
And you think here that reasonable interpretation doesn't exist?
Correct. And our position is that the prosecution at trial failed to establish that for a couple different reasons. So, as I was saying, the surveillance video undercuts the prosecution's other evidence presented at trial, which is an interrogation video where Mr. Williams does not confess to the crime at issue in this indictment. Simply put, there is no confession here at all, and the surveillance video clearly shows that Mr. Williams did not have an intent to steal.
Doesn't the undercutting create an issue of fact for the jury to resolve?
It does, Your Honor, but the jury, in making that determination, is only allowed to make reasonable inferences, and here we are saying because of the evidence presented, the jury reached an unreasonable conclusion in concluding that Mr. Williams had the intent to steal. So first, the surveillance video that the prosecution itself put into evidence at trial is entirely exculpatory. The video captures the entire time that Mr. Williams spent in the CVS store, all 75 seconds of it, from multiple angles. It shows that Mr. Williams entered the CVS, walked purposefully to aisle 10 to grab 2 cans of Red Bulls, walked to the cash registers with those Red Bulls, and left the store without removing any items. No rational jury can watch that surveillance video and conclude that Mr. Williams had the intent to steal. Second, the interrogation video is not a confession to the crime that Mr. Williams was charged with in this indictment.
Let me just back you up for a second on the store video. I'm not sure I would agree that it's exculpatory, but I'm not sure you have to show that, right?
You're right, Your Honor. We don't have to show that it's exculpatory, but I'd like to highlight a few moments where it shows completely innocent conduct by Mr. Williams. So first, at the beginning, at timestamp 9:43:45, he enters the CVS with a plastic bag in his left hand. He walks immediately right to the store, down aisle 9, glances back over his shoulder once, not twice, not several times, as respondent contends, and then he continues to aisle 10 where the Red Bull coolers are located. He takes the 2 cans, and then he walks past the exit. At that point, multiple people are entering and leaving the store, so the automatic doors are triggered. If he had an intent to steal, that would have been the perfect opportunity for him to take the 2 Red Bull cans and flee the store. Also, he made no attempts to conceal the cans of Red Bulls. He was carrying a plastic bag. He was wearing pants. If he wanted to steal, he could have put those 2
But
cans of
isn't
Red
that
Bull.
equally consistent with him seeing if that was an opportunity where, in fact, he could get away with what he may have intended?
Your Honor, at that point, he was walking towards the cash register where store employees were located. So based on this evidence, we would say that if he wanted to get away with it, he wouldn't have approached the store employees and continued walking towards the cash registers. After he passes the exit, at that point, a store manager stops him and tells him, "Stop, you don't belong here." And she takes the 2
Sorry,
cans
when you
of-
say passes the exit, that's en route to the cash register, is that right? I
That's
think in the
correct.
video, we can't see where the cash register is in that frame.
You're right, Your Honor. It is difficult to see, but the cash registers are located. So there's 2 sets of cash registers from the testimony at trial. One is the regular cash registers with the person behind them, and then the other is self-checkout. So he is closer to the self-checkout, although he's not quite there. So he's approaching the self-checkout registers, and the exit is right before that, but he passes the exit on the way to the self-checkout registers where there's another Red Bull cooler located. So at that point, he takes the 2 cans of Red Bulls and he places them down onto the Red Bull cooler, and when the store manager approaches him and asks him to give it back, it's about a 15-second long exchange from the surveillance video itself. He gives the Red Bulls back to the store manager and then leaves the store. From this surveillance video, there's absolutely no evidence that Mr. Williams had the intent to steal. Now, I'd like to turn,
Do you look at the evidence in isolation, or do you look at his conduct before he entered the store, the agreement that he signed? Is the jury allowed to consider it in a collective manner?
of course, Your Honor, and so do we. We are looking at the totality of the evidence here. So on the intent to steal point, I also want to point to the prosecution's evidence of intent that came from the testimony of the shift supervisor, Letitia Menifee. Here, most of what Ms. Menifee testified to is consistent with the surveillance video. However, any incriminating statements made by Ms. Menifee are directly contradicted by the surveillance video itself, and I'd like to point out four key differences. So first, she said that Mr. Williams entered the store, quote, doubled back and stood in the vestibule while looking inside. That's at Appendix 77. This did not happen in the surveillance video, and as I'm sure you've all watched for yourself, it didn't happen. Once inside the store, again, he walked purposefully to aisle 10 to get the Red Bulls. Next, she said that Mr. Williams entered the CVS empty-handed when the video clearly shows he was carrying a plastic bag in one hand. She also said that Mr. Williams slammed the Red Bulls down on the cooler, but at that point, he had already placed both cans of Red Bulls on the cooler when the store manager asked him to leave. And finally, she said that the store manager scanned the Red Bulls for security procedures, and we know that that did not happen based on the surveillance video. So taking all of that evidence into account and looking at the totality, we argued that it is irrational for the jury to conclude that Mr. Williams had the intent to steal when witness testimony is contradicted. Any incriminating witness testimony is contradicted by the surveillance video, and the video itself does not.
Isn't that the jury's prerogative to determine what they're going to believe and what they're going to find credible?
It is, Your Honor, but even here, as I said earlier, the prosecution still needs to prove their case. And
Let me ask you this. Take the four facts you just ran through. Why would any of those, even if from the testimony, why would any of those be incriminating? That is, suppose he walked into the store empty-handed, why would that bear on, I mean, I've walked into CVS empty-handed. I don't think that's an indication that I intended to steal something.
Your Honor, I think, so you're right that
Why
it's
the
not-
fact that, I mean, I've walked into a CVS and paused because I didn't know which way the stuff I wanted was. So if that were true, why would that indicate an intent to steal something?
So I think the first part of Menifee's testimony where he doubled back and went back inside, what the prosecution argued at trial was that it was incriminating because he was trying to see what's happening in the store and deciding whether he could potentially go in there. So our point is that testimony that was
Yeah, but
presented
for
to the
evidence to be probative of a material fact, or really of any fact, it has to make it more likely than not that the proposition is true. So going into a store and pausing to look around doesn't seem to me to be probative of whether you intend to steal something or whether you're trying to figure out where something you want to buy is.
And that is the point that we're trying to make here too, Your Honor. There is no evidence, there's no witness testimony here that
I mean, I guess the
would.
question I'm getting at is, I understand your point is that when you look at the video, none of this actually happened. But even if it happened, I don't understand why it's probative. And maybe that's a better question for me to ask the DA.
Your Honor, again, I think what we're arguing here is there is absolutely no evidence that's probative of Mr. Williams's guilt, whether it's the witness testimony or the surveillance video, because everything shows that he only engaged in conduct as you described that any normal person would have done, and he did not enter the CVS store at 300 Park Avenue South with the intent to steal.
Did he enter unlawfully?
I will get to that next, Your Honor. So on the interrogation video, he was issued a trespass notice in September of 2016, so about 4 months earlier than the date of the incident. However, despite respondents' characterization of this video as a confession, this is not a confession at all. So he was issued that trespass notice, but there are various moments in that interrogation video that indicate that he did not understand the full scope and consequences of that trespass
Would that have been a
notice.
defense to unlawful entry?
Yes, Your Honor, and his trial counsel did argue that.
Wait.
That would mitigate or somehow negate the lawfulness of his entry, that he didn't understand what he had agreed to 6 months earlier?
Oh, sorry. To be clear, it would not negate the trespass itself.
It would not negate the fact that the entry was unlawful, right?
Correct, yes. However, the import of the interrogation video and the statements that he made go to his intent to steal.
What about the claim that Red Bull was involved in that incident also? Or, I'm sorry, never mind.
So back to the interrogation video, I want to flag that every single material fact that he made in that video, where he was, when he was there, what happened inside the store, his own actions inside the store, all of these facts are simply not on the surveillance video. The only rational conclusion to draw from the statements he made is that he's admitting.
So is it your claim that every movement that he made was included or covered by the video? Every angle, every movement?
From the surveillance video, it did capture all angles from the store.
So
and
all of his movements were covered? Is that what you're saying?
based on what I saw in the interrogation video, I think most of them were covered. There are some
But not
angles.
necessarily all.
All the relevant movements are covered. So you can see where he is in the store, what he's doing.
How do you know it's not relevant if it's not on the video? We don't know.
Well, Your Honor, the point is, from the time he walked into the store, from the time he left, we can see where he goes and what he picks up. And I think there is one area where we can't fully see the interaction. It's a 15-second angle. But other than that 15 seconds, again, he's only in the store for 75 seconds total. Other than that angle, we can see every other movement and every other action in the store. So I see.
So, but what about the interrogation video? Is it your argument he's not confessing to the theft of a Red Bull?
Our argument is that he's not confessing to the theft of 2 Red Bulls at 300 Park Avenue South on January 19th, 2017.
He may be confessing to the theft of Red Bulls at some other time and location, though, right?
And that
But
is
isn't that for the
exactly
jury to
Isn't that,
determine?
yeah. What
It's for the
what Judge
jury to
Rivera-
determine whatever may be this level of confusion.
It is, but here, again, because of the objective surveillance video, and again, that's sort of what makes this case unique compared to other instances, we have the entire incident captured on
Couldn't
video.
the jury make a determination that there was a point of clarity within that video, that they could make that finding?
It could, but here it was irrational for them to make the conclusion that Mr. Williams intended to steal exactly because of all of the evidence. And if I can just wrap up.
But if he's at the register, he's approached by an employee, why not just offer to pay it? Doesn't that allow the jury to infer that the intent was to never pay?
Well, Your Honor, his failure to offer to pay does not mean that he intended to steal. It's not equivalent in that way. So, once he was stopped by a store manager telling him to leave, he didn't put up a fight, he didn't argue with her, he gave the Red
Couldn't
Bulls
one
back.
argue that that was consistent with his guilt, being caught before he could complete it?
No, Your Honor, because he
And trying
was-
to get out before it goes any further?
No, Your Honor. I think he was simply just following the instructions of the security officer, returning the Red Bulls, and then walking out of the store.
And you're saying it wouldn't be reasonable for a jury to conclude that the alternate motivation was he just wanted to get out of there before it escalated to a detention or something like that?
Yes, that is what we're arguing, and he could have.
Why would that be impermissible for a jury to make that conclusion?
So it's impermissible because the evidence, because of the surveillance video, if he wanted to leave before it escalated or got out of hand, he had the opportunity to do so about 30 seconds before he was asked to give the Red
No,
Bull.
but I'm saying it's the confrontation itself by the manager that says, uh-oh, I better get out of here now before this becomes an arrest or a detention of some sort.
Well, based on the testimony in the record, the manager never told him that, he's going to be arrested, or she just said, stop, you don't belong here, give me the Red Bulls. So he followed that order. She did not say, hey, you have a trespass notice. Hey, you're going to get arrested for a crime. You're going to be charged for burglary. So based on the evidence, I don't think it's reasonable for us to infer that he knew that it would escalate. She just asked him to give the Red Bulls back, and he did so and walked out of the store.
Is it not reasonable to infer that if you don't offer to pay, you didn't have the money to pay to begin with?
I would say no, Your Honor. I think, again, if you're confronted by someone in a position of authority telling you you don't belong here and give me back the merchandise, you would give it back and leave the store. And maybe he went to another store to try to buy those
And that
kinds of
a lack
Red
of
Bulls elsewhere.
protest, you would say, is consistent with he was doing nothing wrong?
Yes. Yes, Your Honor. And just to conclude, for all of these reasons that we discussed, we would ask the court to vacate Mr. Williams's conviction. Thank you.
Thank you.
Your Honors, and may it please the Court, Anna Nachik for the people. Under the deferential standard applicable to a claim of legal insufficiency on appeal, which requires this court to uphold a verdict if there is A, valid line of reasoning and permissible inferences from which the jury could have concluded the defendant was guilty beyond a reasonable doubt.
What do you say with respect to the argument that all of his conduct was equally consistent with innocence, just being a shopper?
Your Honor, we disagree that his conduct was that of an innocent shopper. And also, even if we accepted that, we also have the confession where he admits that that during the second week of January, this is January 19th, he went into the CVS at 300 Park Avenue South and he took 2 Red Bulls.
Let's pair the two things apart. If all you had was the video, would you have legally sufficient evidence?
Your Honor, we believe we would because defendant's conduct in the store is not.
What specifically, what motions that he made in the store would you point us to?
Well, Your Honor, walking by the store first and then coming back in, the inference that can be drawn from.
I'm puzzled by that because I think I probably do that all the time. I walk by, I think, oh, I should pick something up in CVS or some other place, and I turn back around and head in the door. Is that really a reasonable inference? I would hope that when I do that, folks don't think, oh, she must be intending to come in here and steal something.
Well, it's that inference that goes into his arguably furtive behavior also inside the store.
And what is that specifically?
It's that he goes down aisle 9, which is not where the Red Bulls are located. He looks over his shoulder twice. He looks over once, and then at the end of the aisle, he looks over and he appears to watch the area of the cash registers. The inference that can be drawn from that is defendant was trying to ensure that he was
It
not.
has to be a reasonable inference, right?
Yes.
So how is that a reasonable inference? I mean, I would think that the reasonable inference, and maybe your view would be, it's not the only reasonable inference, but would be, I'm looking for the register, I'm trying to figure out whether I know how to work the self-checkout well enough that I should do that instead of going to look for the human being. I'm trying to understand why those particular actions are consistent with an inference of intent to steal.
Because, Your Honor, they all have to be taken together. And after he appears to look towards the register, he takes the Red Bulls. And then when he's approached by a store employee, he doesn't offer to pay. He doesn't explain, oh, I maybe have cash in my hand. He doesn't.
Well, except that he's confronted by the store officer, security officer, doesn't tell him, you have to pay for these. She says, you don't belong here. In fact, he doesn't belong there because there's a trespass order, right?
True, and she also says, give me back the items, and he doesn't try to explain.
Right, but if he doesn't belong there, he can't, he needs to get out of there so he's not arrested for trespass.
And the only other option, I guess, would have been for him to say, I do too belong here, and I want to pay for them. It seems because of the content of the statement, as the Chief Judge says, leaving is actually what one would expect him to do, and saying I intend to pay for them would be more confrontational.
Well, he also apparently does get upset because he gets upset and he slams the Red Bulls down. That was the testimony at trial. The fact that he gets angry also shows that
What do you say about the claim that the video shows the contrary with respect to slamming down?
Your Honor, the testimony at trial was very clear that he got upset and slammed them down. This portion of the video is shown very small across from the, from all the way across the store. I can't personally tell when he puts the Red Bulls down, but the evidence at trial, the testimony at trial was very clear.
The videos cover every second of every movement he made in the store.
Your Honor, not every second of every movement. It does cover a majority of while he is in the store, but it is from all different angles, and they do all have to.
There's no video of him drinking a Red Bull, right?
There is not, and
Back to your last statement, the slamming down. I'm trying to figure out what could reasonably infer from slamming down a couple of cans of Red Bull regarding intent. I'm not making that connection, which is troublesome.
Well, Your Honor, it's that he slams them down and also doesn't offer to pay for them. And also, we have to.
Because he's been told he doesn't.
Consistent with, I'm indignant that you are approaching me. I'm just a customer.
Your Honor, even if it's equally consistent, this is intent we are talking about. And when there are conflicting inferences regarding intent, that is a jury question.
No, I think that's a different issue. If the piece of evidence is equally susceptible of an innocent and not innocent explanation for something, it's not probative, right? To be probative, it has to make a proposition more likely than not. And if I have a trespass order, I might think to myself, I'm really thirsty. I'm going to go into Red Bull and go to the CVS and buy a couple of Red Bulls. And I could be really upset that the security officer recognizes me and says, oh, no, you're the guy who has a trespass order, which is exactly what actually happened. I might get very mad that my plan didn't work, slam down and go. But that has to be probative of my intent to have stolen them.
Your Honor, we believe it is, and the jury also believed that it was. The jury thought that all of this.
We don't know what the jury relied on.
Well, what we do know is that the jury deliberated on this issue and found that defendant intended to commit a crime at the time.
But on appellate review, where we're talking about whether or not permissible inferences have been drawn from the evidence, I think it's incumbent on you to tell us, when we're discussing a particular piece of evidence, like slamming down 2 cans, what a permissible inference would be from that, other than guilt. You know, what did the jury get from that?
The permissible inference is that he knew he had been caught trying to take the Red Bulls. And we also have to take this with his confession when he admits that he tried to take 2 Red Bulls and that the store manager took them
At
back.
some point, but not, it appears, there are significant inconsistencies, are there not, between his statements in the interrogation video and the video in the store?
There are inconsistencies, but there are enough consistencies for the jury to have
Well,
determined.
but
he's
isn't
caught.
on this point what's relevant, at least with respect to what appellate counsel is arguing now, is that he didn't know he couldn't be there. I thought that was their position. He didn't know he couldn't be there. So one would assume he would be upset and offer to pay because he thought he could be there.
Well, Your Honor, I think the evidence, the reasonable inferences that can be drawn from the evidence that this trespass notice was explained to him, that he said he understood the trespass.
I understand. I'm talking about the way counsel has argued this case to us. They've argued it that the inference that one would draw from that interrogation with respect to this issue is that he did not understand that this notice applied to this CVS. And if that's the case, if that's the argument, someone coming up to you and saying, you don't belong here, one would say, of course I belong here. Why wouldn't I belong here? Or offer to pay.
Well,
As opposed to, oh, I've been caught, I got to go because I violated the trespass notice. He may believe, oops, I've got to go because I've been caught because I was going to steal the Red Bull. That's true. That's a different argument. But with respect to an awareness of the trespass, seems to me it's foreclosed by the argument that counsel is making to this court.
well, Your Honor, an innocent shopper would have said something in response to that confrontation, especially, you don't belong here, give me back the items. She's saying both, you don't belong here, and an inference can be drawn that she's talking that he's stealing the items, and he doesn't protest that at all. And I would also point to
But
his
why can you draw the inference from her saying, you don't belong here, that he's stealing the items? Did I understand you correctly?
Because she says, you don't belong here and give me back the items. And he doesn't protest either, oh, I wanted to buy these items, or what do you mean I do belong here? And I also want to point.
But wait, why is that not something which suggests that he knows he doesn't belong there? And how does it suggest instead that he's intending to steal the Red Bulls?
Your Honor, it can suggest both, that he knows he's not supposed to.
Why specifically can it suggest that he's intending to steal the Red Bulls?
Because he doesn't offer to pay for them.
But in the face of a statement that if, you know, it were not for the statement, "you don't belong here," perhaps that argument would have some more merit. But he's just been told he doesn't belong there. So how is his response consistent with an intent to steal?
Because when she says, "Give me back the items," he could have said, "I just wanted to purchase these."
But she just said, "You don't belong here." So if we look not just at the specific act of leaving the store without offering to pay, and couple it with what's prompted that response, which is her statement, "You don't belong here," how is there an inference of intent to steal?
Your Honor, because of also the rest of his conduct. And
Okay, but if we look specifically at this action that you're asking us to rely on, which is not offering to pay, given her statement, how can we infer, or why would it be more likely than not, that that's because he was intending to steal the Red Bulls?
Your Honor, opposing counsel mentions that he maybe had cash in his hand. If he had cash in his hand, a reasonable, innocent shopper.
I'm not asking about cash in the hand. I'm just saying, if we look at his action in relation to what prompted it, which I think we should and probably must, which is her statement, how is that response something that could yield an inference that he intends to steal?
Your Honor, again, it's just that he doesn't offer to pay in any way. And I would also point this court to Exhibit 7, which is the wanted poster. And defendant actually initials that wanted poster during his confession and acknowledges that on January 19th, 2017, he went into the CVS at 300 Park Avenue South and he took 2 Red Bulls. He never said that he wanted to pay for them. And also throughout the confession, even if there's inconsistencies, he never said, "Oh, I was intending to buy those." And that is just inconsistent with innocence. And also, this court can weigh the fact that defendant only a few months earlier had signed this trespass notice and that he knew he was banned from the CVS store. Just turning quickly to the knowingly unlawful entry, defendant had.
Does it matter why he was in fact banned to use that evidence in conjunction with or connection with the alleged theft at issue?
Your Honor, the jury couldn't weigh weigh the prior shoplift for propensity purposes, but it is relevant that defendant had previously
Does it
been
go
given.
to context?
It is context, and it's relevant that defendant had been given this trespass notice, had said that if he, and that Nunes had told him if he entered again, he would be arrested for the crime of shoplifting, and he actually said that instead of trespass, but the trespass notice says that he would be arrested for the crime of trespass. I can touch briefly on the preservation argument if Your Honors would like, but if there are no further questions, we ask that you affirm. Thank you.
Thank you.
Your Honors, I would just like to address a few points raised by respondent. So first, as to the point about.
Does the prior trespass notice come into play here?
The trespass notice itself? Yes, so that is
What is the jury allowed to do with that information, if anything?
I think the jury is allowed to determine whether he was unlawfully there, but for burglary in the 3rd degree, one of the elements, as you know, is whether Mr. Williams knew that the entry was unlawful, so it's 2 separate points. And on the confession, there are a few moments in the video that kind of indicate to us that Mr. Williams did not understand the full scope and consequences of the trespass notice. So at the
Is there not an argument that there were points in the video where he is lucid enough to confess, as the prosecution alleged?
Your Honor, he's lucid enough to confess to some other time where he was inside a CVS store and he drank a Red Bull. But that's not.
The jury determined that, no, he was talking about this instance. He said, "I took 2 Red Bulls," and then he talks about another time, I think, where he took 4 Red Bulls from another place. Is that right? So
Your
couldn't
Honor-
the jury have reasonably decided, you know what, we think that this is an admission to his intent to steal these 2 Red Bulls at this incident, And that's what we decide based on just this statement, forget the video.
So
And he explains what this serial Red Bull interest, stealing, whatever you want to call it, is, right? If he's saying it's related to his health and these other issues, so certainly providing a motive for why he might take this act. But I don't know if I was being clear with my point before. As I understood your argument was that the interrogation video, the inference to be drawn from what he says there is that he did not understand that the notice covered this CVS.
That's
And
right.
if that's so, my point to opposing counsel was, doesn't that then make us wonder and would allow the jury to infer that the failure to offer to play, the failure to be incensed or upset when you're told to leave and you don't belong here is explained, right? You have that contradiction between the position you're taking now and how one would view the video.
I understand the question, Your Honor. So we're saying that the interrogation video showed that he did not understand the trespass notice, but that doesn't mean that he had to then necessarily offer to pay. When he heard that he did not belong here, there are moments in the interrogation video where he doesn't understand that the notice applies to every single CVS, but that does not mean that he has to, at the incident of the crime itself, of the purported crime, that he had to understand at that point that he was there justifiably. So
I'm not sure I'm understanding your argument.
I think
Either he thinks he can be there lawfully or he can't. I took your argument to be that he did not understand that he could not enter this CVS, that entering this
Correct.
CVS would be unlawful, would be a trespass. I thought that was your
Yes.
position, that would be the only inference one would draw from the interrogation. And if that's the case, again, we're back to what's the inference then that a jury could draw when he is approached by, I think it was the manager, anyway, an employee saying, you don't belong here, give me the Red Bulls, right?
I think the inference there is that I don't think that there's an inference of guilt to be drawn there, though.
Okay.
Can you answer my question, because I think we got cut off? So why can't the jury determine, based on the videotape that they saw, that that was a confession to him stealing? And all the other evidence corroborates that, and that's a jury prerogative.
So to your earlier point about the 4 Red Bulls, that was not presented in front of the jury, so that's not an issue here. But the interrogation video itself, where he actually starts making these so-called admissions and saying he was there, he did it, all of the material facts that he's admitting to are not on the video. So our point is simply that because the so-called admissions that he makes are directly contradicted by the most objective evidence in the record, that's the surveillance video, it was irrational for the jury to conclude otherwise. And I can point to a couple of details that indicate that. So at the beginning of the interrogation, Mr. Williams, the detective asked Mr. Williams where he was, and he keeps asking her which CVS she's talking about. He says a couple of different times, this CVS, which CVS is this? Is it the same CVS that starts at timestamp 1453? Later on, he admits that actually the detective had asked that someone had approached him and he had already placed a Red Bull inside the plastic bag and this store manager took it out of the plastic bag. And he just admits it in the interrogation video. But the surveillance video shows that did not happen. He also said that he drank a Red Bull inside the CVS, as you all alluded to earlier.
Isn't that equally consistent for a jury to determine that he's just trying to figure his way out of things? And he's saying different things, and it's up to them to assess the issue of credibility, period.
It is up to the jury, Your Honor, but again, given...
Or what weight to give to any piece of evidence.
It is in the jury's province to decide that, but again, viewing all of this evidence in totality, the surveillance video, all of the material contradictions in the interrogation video that are contradicted by the surveillance video itself, it was irrational in this case for the jury to conclude that he was guilty. So again, for all of these reasons, if the court has no more questions, we'll rest on our briefs, and we would ask the court to vacate Mr. Williams' conviction. Thank you.
Thank you.